This press conference is not where it normally would be because we had an incident in our building, the Ralph Carr building, that is displacing us, and we are grateful for how many members of our community have stepped forward to offer to support us. We're also grateful because nobody was hurt in this incident, and that includes the perpetrator. The way this was handled is a testament to responsible law enforcement, and I want to single out the Colorado State Patrol and the Denver Police Department for my deepest appreciation and gratitude. That's a timely expression of gratitude because today is Law Enforcement Appreciation Day, and what we experienced as a victim was law enforcement leading with a real sense of professionalism, sensitivity, and a commitment to protecting victims, something I know District Attorney Michael Doherty sees on a regular basis. With respect to the building, our overriding concern is how we protect the safety of our employees and the public. We are working with building management and will reopen the building when it's safe to do so. We will be providing more details on that front as soon as we can. We are here today to announce a settlement with a property management company, Four Star Realty. This case, however, is about renters. Too often, renters are nickeled and dimed and misled by property managers and landlords. When renters move out, they are at a particularly vulnerable time, and their security deposits often are not returned to them as the law requires. There are some renters who can act effectively as their own advocates and get their money back and be treated lawfully. Most renters, however, aren't in a position to do that. They don't have the time or the training or the patience. They get mistreated. The law is violated as to them, and that's not right. What this settlement does is provide significant monetary relief in the form of restitution and refunds for consumers who were mistreated and will now get money put back in their pockets. But it does much more than that. This settlement sets a standard for the industry in terms of transparency and fairness. And I want to thank Four Star Realty for their engagement, helping us develop a constructive settlement and a roadmap. I also need to acknowledge my friend standing to my left here, Boulder District Attorney Michael Doherty. As we think about partnering with district attorney offices, we don't have a better model for that than the Boulder County DA's office. In this case, they received complaints about Four Star Realty, and they raised it with our office, and our consumer protection team, many of whom are here with us, worked hard and long to analyze these complaints. They also had another special tool, and that's because State Representative Edie Hooten, former representative I should say, led the way in passing legislation that authorized our office to ensure that property management companies and landlords didn't illegally withhold security deposits. I want to underscore the significance of this legislation because it gave our office, for the first time, authority in this area. And in this case, for the first time, we are exercising that authority. That makes this case a call to action for landlords, for property management companies, and those who work with them and represent them. As Four Star grew, they failed to build the proper systems to ensure that they were complying with the law. They failed to provide tenants with their rights. If you are a tenant or a consumer, this case is also a wake-up call that violations of the kind we're addressing here are ones that our office is committed to stepping up to protect. I've noted this is a settlement with Four Star Realty. They're a property management company. They oversee buildings mostly in Boulder, Fort Collins, Greeley, and Denver. And under the settlement, they're committed to paying up to $1 million in restitution that's going to benefit consumers. It's worth making clear that our investigation found numerous situations where tenants were being charged for things they shouldn't have been, such as when someone moves out, they repainted an entire wall. Maybe it was just a spot that was a concern. And they withheld the security deposit to address repairs that were not caused by that tenant. They also had hidden fees that weren't disclosed in the lease, including ones for rekeying doors that weren't even using physical locks, and it just was a matter of changing an electronic key fob. Again, Four Star cooperated with this investigation. And as it went forward and they saw areas that they failed to comply with the law, they said, we're going to fix it. We're going to comply. And this consent decree that is filed today makes that compliance mandatory. In addition to the restitution, Four Star has agreed to disclose all fees, the rent, and any other costs in a transparent and clear way so that tenants understand what their fees are. They've also committed to a compliance framework where there will be documenting of all photos and records of any necessary property inspections or any withholding of security deposits, and they will make that information available to tenants upon request. They are also committed to the principle that I've mentioned earlier, and this is a critical one for tenants. Ordinary wear and tear is not something that can be addressed by withholding a security deposit. It has to be about the tenant's specific conduct outside of that ordinary wear and tear. Four Star is committing to minimize repainting costs related to filling nail holes and other minor damage, and will specially ensure that any carpet cleaning is truly necessary before tenants are charged for that. Four Star, as part of the settlement, will provide our department with a list of all the tenants who moved out of properties during the period of January 2020 until December 1st, 2023. And they will work with our office on a process to give restitution to consumers who are overcharged. Colorado law is crystal clear. Landlords cannot charge tenants for ordinary wear and tear. Landlords cannot charge fees that were not disclosed. If those principles are violated, our office stands ready to act. We have created, pursuant to a new legislative mandate, a fair housing unit. This is a new form of protecting consumers in Colorado, and that unit has created some resources for tenants, do's and don'ts. How can you protect your hard-earned money? How can you make sure that your security deposits are not being withheld improperly and you're not being charged fees that are illegal? This action is the first of its kind, an action enforcing this law, an action by our Fair Housing Unit. It will not be the last action. We have multiple statutes that we're committed to enforcing. I mentioned the security deposit protections. I mentioned the use of improper fees. We also enforce the Immigrant Tenant Protection Act, the Rental Application Fairness Act, and the Mobile Home Park Act. If you or people you know have had your legal rights violated as a tenant, we need to hear about it. You can let us know about that at stopfraudcolorado.gov. For the property managers and landlords paying attention, this is a wake-up call. You need to look at your business practices. You need to evaluate whether you are following the sorts of compliance that are mandated in this consent decree. I really want to say, in closing, how fortunate we are to have District Attorney Michael Doherty as a partner. For DA's offices across the state, we would welcome this type of partnership on housing or other consumer protection issues, and of course we work regularly on criminal justice issues as well. The type of communication and professionalism that we were able to have between our offices truly is a model. It's how we work best in Colorado, and with that, I will give District Attorney Doherty the stage. Thank you.
Good morning, and my thanks to Attorney General Phil Weiser for bringing us here today. Today, the complaint and consent judgment represents the culmination of over a year's worth of work between the District Attorney's Office and the Attorney General's Office in response to complaints from tenants of Four Star Realty. And the consent judgment really is a landmark settlement in that it's the first of its kind in Colorado, and I agree with Attorney General Weiser that it will not be the last. Four Star Realty specializes in managing off-campus housing options and properties for students in Boulder, Fort Collins, Greeley, and Denver. They currently manage approximately 4,600 properties in the state of Colorado. And the action was brought for them unlawfully withholding money from security deposits. Security deposits, it's not uncommon for them to be between $5,000 to $10,000. Those security deposits be withheld in whole or in part unfairly and unjustly. Also, there was a lack of transparency by Four Star Realty in charging unfair and deceptive fees for tenants. Our office prioritizes fighting for community members who've had their rights violated. And in this case, we could not have done it without the help, partnership, and leadership of Attorney General Weiser and his office, since this is a civil action. The District Attorney's Office has authority under the Consumer Protection Act to bring a civil action, as does the Attorney General's Office. But as Attorney General Weiser indicated, in 2022, the legislature gave the Attorney General the power to bring civil actions when security deposits have been violated by landlords, because of the unfair power dynamic that exists between landlords and tenants all too often. Over the past couple of years, our office had received complaints from tenants, many of whom were college students, parents of those students, the City of Boulder, and the University of Colorado Boulder, all reaching out about concerns that they had about security deposits being withheld in whole or in part by Four Star Realty. The complaints ranged in terms of the nature and total losses suffered, but one thing was abundantly clear, that Four Star Realty was taking advantage of tenants, many of whom were college students. And after receiving these complaints at the District Attorney's Office, we reached out to Attorney General Weiser and his staff, who've been outstanding partners throughout this effort, to make sure that we could reach the right outcome on behalf of the tenants who were impacted by Four Star Realty, and also to make sure we're doing right by all the tenants who rent properties here in the great state of Colorado. I want to thank the college students, their parents, the City of Boulder, and CU Boulder for alerting us to these concerns. And I can't thank the Attorney General enough for the partnership and hard work that his staff provided from the very beginning in making sure that we could do right by the tenants who were impacted by Four Star Realty and the property owners that they represent. And I want to stress a couple things that the Attorney General hit on, because I think it's really important going forward for people to be aware of their rights. It's important to remember that security deposits are the property of the tenant, not the property of the managing company or the property owner. It's the property of the tenant. That's held in trust by the property owner. Landlords are not permitted to use that unless there's actual cause to do so. And under the law in the state of Colorado, normal wear and tear doesn't qualify as actual cause. So when a company comes in when a tenant's left the property and they're caulking tile or painting walls or fixing loose doorknobs, whether or not the tenant actually caused any damage to the property, what they're actually doing is maintaining, if not improving, the value of the rental property so that they can use it and market it and rent it again in the future. But they're doing it on the backs of the tenants who've already left. For example, and you'll see this in the complaint that was filed and the consent judgment that was reached, there's a move-out coordination fee that was charged by Four Star Realty. It was charged to hundreds of tenants who were completely unaware of it when they engaged in the contract initially. So as they're leaving, they're charged what was referred to as a move-out coordination fee that had never been disclosed on the front end. And I would stress for all of you here and for those who are watching to think about the transient nature of college students. Just by the very nature of being a college student, you're packing up, you're leaving, perhaps even leaving town, and you're looking to move on with your life and looking to move on to a new place. Some of those students, some of those parents would speak up, and in fact, Four Star would then refund those costs. But far too often, tenants would pay the cost because they're looking to move on with their lives. If you're currently renting, or if you recall the last time you rented a property and you were moving out, you really are in a position where you can be victimized here because you're paying the fees so that you can move on with your life. And what this consent judgment stands for today is that landlords can't charge fees that weren't disclosed in the first place. Landlords can't charge fees for things that were not actually caused by or damaged by tenants. So when you look at today's consent judgment and what it stands for, there's a couple things I would highlight. First is the restitution of $1 million for tenants who were impacted by the allegations that are laid out in the complaint filed by the Attorney General's office and by our office. Also, it's an obligation for every company going forward to disclose fees up front. And I think that's of paramount importance here for property owners to be aware of, that these fees have to be disclosed on the front end. And they can only charge for repairs due to actual damage or actual cost by the tenant. So the repainting of a property just to make the property look better and perhaps get more rent the next time around, that can't be done on the back of the tenant. And I would highlight three significant things about today's consent judgment before we break for questions. First, I really want to stress the collaboration and teamwork between the District Attorney's Office and the Attorney General's Office in serving the residents of Boulder County, but this will have a much broader impact than just Boulder County. It is a clear mandate to property owners throughout the state of Colorado and represents what tenants' rights are and how they must be preserved going forward. This case, in a lot of ways, is unique for the way, in the manner that the Attorney General described, but it's also absolutely essential. And this partnership came about as a result of the collaboration between the District Attorney's Office and the Attorney General's Office. And I want to thank Chief Deputy DA Christian Gardner-Wood for all the work he put in on behalf of our office in working with the AG's team. Second, while this investigation was pending, and this is an important point, Four Star took proactive steps to improve their business practices. Over the last several months, Four Star proactively worked to better serve their clients, the property owners, better serve the tenants, and better serve the community. And through their actions leading up to today, but also including what we have in the consent judgment, it really is a roadmap and industry standard for other property owners going forward. Four Star, especially over the last several months, has been an engaged and willing partner in seeking to improve their practices for their tenants, but also for those that they serve on the property owner side. And it really will serve as an industry standard going forward. Make no mistake about it, folks, Four Star could have fought this in court, and it would have been trench warfare for years, back and forth between the AG's office, the DA's office, and counsel for Four Star. This settlement, the outcome we reached today, the $1 million in restitution that they're going to have to pay within 1 year, is a testament not only to the work by the AG's office and the DA's office, but also by the willingness of Four Star to recognize how they, but also the industry, can do things better. There are many property owners out there today who aren't meeting the standards that Four Star is and will be going forward. And this clearly is a message that what Four Star is now doing and what they have in place has to be followed by other property owners and property managers. And finally, today represents a very significant step forward for the tenants and renters throughout the state of Colorado. The more transparency we build into lease agreements, the more we do to reduce fees, the more we lower costs for people who are struggling to get by and struggling to pay rent. There are a lot of people who are renting property throughout the state of Colorado. They should do so when the costs are transparent and when the fees are just. Today's $1 million settlement is a very positive step in the right direction for us as a state. And I want to thank the Attorney General for his partnership and leadership on this as well. And we're happy to take any questions you have. Thank you.
Let me offer two final points before questions. First, I announced several weeks ago a settlement also of $1 million against Wyatt's Towing. What that settlement and this settlement have in common is both involved a business scenario where if you advocated for yourself because you were in a position to do so, maybe you were a lawyer or even a state senator, you were treated legally. But if you were tired, were busy, didn't realize what your rights were, your hard-earned money ended up in someone else's pocket. That's not okay. This action, like the Wyatt's towing action, is about fighting for consumers. The second point, I've actually talked to some renters who have said things like what happened here happened to them. A lot of renters say, I have not gotten my security deposit back legally. Today's message is that's not okay. The ordinary wear and tear or even improvements that DA already talked about should not be happening on your dime. If it is, let us know about it so we can fight for you. We'd welcome your questions. Yes?
Gentlemen, many of the line points have been underposed here. Are there any other ongoing investigations that other property management companies you can tell us about?
I'm going to repeat the question just in case not everybody heard it. The question is, are there other investigations that my office is in a position to disclose? And the answer is not at this time. I can confidently say and will repeat, this will not be the last such matter that we bring forward to advocate and fight for tenants. We want your engagement. We need your engagement. I mentioned the site stopfraudcolorado.gov. For those tenants who see things that we're addressing here, who say, wait, that happened to me, this is a clarion call. Let us know about it. Thank you. Yes.
Hi, I'm Tatiana from Colorado Sun. Just piggybacking off of that, I don't think I've ever received a security deposit back in all my years of living in apartments, what makes me think this is like probably a common practice. And so I wonder if you agree and why a 2022 law is just being enforced now. Like, was this particularly egregious, or like what is there something important about this particular property?
All right, Tatiana, I think you asked 3 or 4 separate questions. I'm going to do my best to get them all. If I don't, please follow up. First point that you made is another version of what I said. You are not alone as a tenant who has told me, wait a minute, I never got my security deposit back. The key message from this action, that's wrong. DA Doherty said it well. The security deposit is the property of the tenant held in trust. It doesn't belong to the landlord. And if the landlord seeks to use it for purposes that are improving the property or addressing ordinary wear and tear, that's wrong, that's illegal. The 2022 law was passed at the end of the session of 2022. I'm not aware when it exactly went into effect. Sometimes there's a lag. But I think it's fair to say this became the first high-profile, high-priority matter that our office worked on once we had that new authority. I also want to add that standing up the housing unit, which was also provided by the legislature, took a little bit of time. We now have some tremendous lawyers ready to go. So as you look at the way things work, within this 18-month period, we have gotten this new authority, gotten a new unit authorized, hired lawyers, found this partnership, and announced what is a, as you put it well, unprecedented and impactful settlement that hits a principle that you and others need to know. If you don't get your security deposit back, you have a right to ask why not. If they can't document why it's being used for lawful purposes, that's unlawful for them to do. Let us know about it. You asked a number of questions. Did I touch on them all?
Yeah.
Do you want to add anything to that?
No, not to that.
Okay.
Lucas, hi with BizWest. Thanks very much for taking my call. I was curious, did your investigation find that any fees were being improperly charged or policies improperly in place in other markets where Four Star operates, be that Greeley or Fort Collins or Denver, or is it this specifically in Boulder?
That's a very good question. Boulder was the primary focus, but I believe we looked a little more broadly. Do you have a?
Sure. So we focused on Boulder County. The victims had come forward in Boulder County, and that's why our office was connecting with them and then reached out to the Attorney General's office. So the venue for this is Boulder County. However, as you highlighted, they own properties outside of Boulder County. This would apply to their properties outside of Boulder County as well in terms of the consent judgment, and quite frankly to property owners all throughout the state of Colorado.
Can you clarify the consent judgment? I've heard $1 million, but I've also heard up to $1 million, which could mean $10.
Thank you.
How does that go about?
The restitution will be as close to $1 million as possible. The reason it's not $1 million on the nose is some of that money may cover certain costs incurred in the investigation itself. So the restitution dollar will be very close to $1 million. If it's a little short than that, it's because the out-of-pocket expenses in this investigation are also going to be covered from that pot of money as well. Can I add one thing? Please, yeah.
It's also the Attorney General's office focus will be identifying individuals who were not fully reimbursed for their security deposit. So some of that uncertainty about how close it is to $1 million is around how many people are identified that are owed restitution. So that work still remains to be done. What is certain is that there's a payment plan that Four Star has to comply with where they have to pay the $1 million by the end of 1 year. And then the amount that is used for restitution will depend on our ability, collective ability, to identify individuals who were shorted or deprived of their security deposits or paid unjust, unfair fees. So that still remains to be done. We identified victims throughout this process, but there are more people out there, and I imagine we'll start to hear from individuals who hear about this consent judgment going forward.
And for those who did get charged illegal fees or had their security deposit used illegally, it's the same website, stopfraudcolorado.gov, where you can get information, let us know. We have a question right here, yes.
Yeah, Jordan, can you talk us through the nexus of the complaints, like how they came into your office and when you realized this was kind of a larger, I don't want to call it conspiracy, but a larger problem? And then you mentioned that move-out coordination fee. Can you tell us about that one?
Sure. I'll break down some of those questions. So the first question was how our office first became aware of these issues. We have a close working relationship with CU Boulder and also with the City of Boulder and the respective agencies within each that work with tenants. So they had reached out to us, but we also heard from tenants and parents who were contacting us. We have a community protection unit in our office that is available for any consumer protection violations. We have, as I noted, civil authority to bring a Consumer Protection Act. It's not normally what we do within the district attorney's office. As you know, we handle criminal cases in large part, almost exclusively. But in this case, when we started to hear the number and nature of the complaints, we reached out to the Attorney General's office and thus began a joint investigation and partnership into this. So that, I think that answers your first question. In terms of the move-out coordination fee, I would have to check on the details. My recollection is those fees varied by unit, but there was a move-out coordination fee that had to be paid, and there was a period of time, roughly a year and a half, where hundreds of tenants were paying that fee, although they had not been informed of it when they first signed the rental agreement. And what I highlight for you, too, is that some of this around the timing is tenants are often renting properties and entering into lease agreements before they've even arrived in Boulder. So thus is the state of the real estate market and the college population, that they're agreeing to rent an apartment that they've seen online but not actually seen in person, and they're then moving in after that. So they're relying on what information is being shared with them on the front end to determine how much they're going to be charged ultimately. That move-out coordination fee was not being shared on the front end and being put on them on the back end as they were moving out of the property.
Yes.
How soon can will tenants be expecting to get the restitution? What do they have to do to get it?
If you're a tenant and you've been mistreated, what you have to do is let us know about your mistreatment at stopfraudcolorado.gov. We're going to be able to go through Four Star's records and contact tenants. So if you don't contact us, that doesn't mean you're not eligible, but if you do, obviously the benefit is we know where you are. One of the challenges we're going to have, and this is why this is a hard question, some people will be easier to locate than others. So as Dee had already noted, we're going to have this pot of money and we're going to be figuring out the nature of the mistreatment and then trying to figure out how much money we give to each people and how we find them. So the answer is going to vary depending on how accessible the individual is. But we're going to get right on it.
Is it possible that the amount that would be paid to, or that would need to be paid to folks to make them whole in restitution could exceed $1 million? I mean, say you find more folks than you anticipate, and that $1 million pot no longer exists.
A challenge in a case like this is the $1 million was our best estimate, sort of rough justice. We have risks on both sides. Dee had already mentioned the other risk earlier. we can try really hard to find all the tenants who've been mistreated and end up short, not having been able to give all the money back. Or we could have the opposite problem, more people mistreated an amount than money we have, in which case, ideally, we'll be able to get a sense of that and prorate it. We're going to do our very best to get all the money back to people who've mistreated, and if we come up to that problem, we're going to have to figure out how to deal with it. I will say, of the two problems, that's the better problem to have in the following sense. I am concerned, given this population, how transient they are, that it will not be easy to locate everybody. And just one more thing to give people a little bit of context. We had a case that was, I think it was close to $8 million against CenturyLink, where they had charged illegal fees. They gave people this promise, a price lock guarantee, but then they kept adding this fee on top of it. We got them to refund all that money. They gave the money to us, and then we had to try to find all the people who were essentially mistreated. We did our very best, but I think we came up against the problem I noted is there as well. Let's go for, yes.
You have touched on it a bit, but I'm curious how the population of college students perhaps enabled this company to do this in different ways or for a longer period.
I want to underscore this point because the housing unit that we provide is within a broader civil rights commitment of our department. And the people whose rights tend to be most violated are those who are most vulnerable, those who may have the hardest time advocating for themselves. So students are a vulnerable population because they lack some of the experience and sophistication to be able to know what their rights are and advocate. They're often transient, as DA Doherty mentioned, which puts them at a disadvantage. They're moving quickly. And one of the other challenges, if they have moved elsewhere to another state, it's really hard to stay on top of it. That absolutely made them more vulnerable, but I want to emphasize there are lots of other vulnerable populations. Think about veterans, think about single parents who don't have the time or wherewithal to be their own advocate. And so the people who are most likely to be mistreated as tenants are often categories of vulnerable people, and the students in this case are absolutely one of them. Do you want to add anything?
No.
Okay. Yes.
How many, to just like try to understand the scope of the problem, like how many tenants in Boulder, in how many buildings does Four Star own? So I'm just trying to figure out like how many buildings they own in Boulder or the whole state if you know, and then about how many tenants in those, if you know.
We can get back to you if the DA doesn't have that on top of mind, because that's a very good question. I don't know if it's specified in the complaint itself, which all of you should be getting access to along with the press release. But if you have questions like that, detailed questions, Lawrence Pacheco, our communications chief, can see if we can get you an answer. Sounds like you don't have it top of mind.
So one of your questions was total number of properties that they manage. So keeping in mind they're managing the properties for property owners, and as of 2023, they had approximately 4,600 properties that they manage through Boulder, Greeley, Fort Collins, and Denver. I would have to get back to you on how many within Boulder, and I can get that information for you. And as the Attorney General indicated, Lawrence Pacheco will be available after to give you some more details on that.
Yes.
Do they just own property here in Colorado, or do they own places in other states too?
My understanding is they're only a Colorado company. That Four Star operates here in Colorado in the cities we mentioned. Yes.
Scope question, but knowing the housing market in the last 5 years and how much it's grown and how much of this is going on, knowing that Four Star grew too quickly, do you anticipate this is a problem with a lot more of these management companies that grew with the height of the housing market?
Yes. I am very confident, sounds like we've heard Exhibit A in this room, that a lot of tenants experienced exactly what we described in this complaint and may not have known what their rights were or just may have grown frustrated. We're going to go down the list. Other complaints that now come in, we're going to be able to look at them. And other companies who made this mistake, they face a choice, and it's a choice that DA Doherty said. And I want to commend Four Star. Companies can either say, we made a mistake, we need to do better, take responsibility and make it right. That's what Four Star did. I hope other companies come forward in that spirit. If they don't, and instead they want to do the hand-to-hand comment litigation, game on. We're not afraid to litigate these cases. This is about protecting the rights of the people of Colorado. We will go to bat for the people of Colorado. Yes?
Between the number of properties they own in the state, are you concerned about being able to make everyone whole who was taken advantage of by the company?
I have two concerns. I don't know which one is the more likely one to end up being proven out. I'm concerned that we're not going to have enough money to give to everyone who was cheated. I'm also concerned that we're not going to find everybody, because this is a transient population and a lot of people may not even be in Colorado anymore. They may not know about this, and we're going to have trouble giving all the money. I don't know which of those is likely to ultimately predominate, and I don't know if we know exactly what % of people stayed in state who go to see Boulder.
So I don't have that number, but I will highlight for you that a lot of work by the Attorney General's office and our team was done to look at the number of complainants who had come forward, but also taking a snapshot of other properties to figure out what sort of loss had been suffered and by how many people. So this $1 million figure was not just a shot in the dark. It was based on a lot of work that's been done looking at different properties and different losses suffered by individuals. And I want to recognize that what the Attorney General just hit on, which is Four Star could have sought to litigate this over the long haul. And some of these security deposits or the fees that were charged are a couple $100s, and we would have had a lot of trouble tracking down individuals to come forward and testify perhaps. But Four Star instead looked at how can they do a better job for their clients, the property owners, a better job for the tenants that they choose to serve, and also a better job for the Boulder community and the other communities that they operate in here in Colorado. And that's why this consent judgment was reached and the $1 million settlement as part of it. I imagine that we're going to hear a lot from former tenants who had used Four Star as a managing company in the past, and you'll be able to get updates from the Attorney General's office and our office on how much of that restitution is paid out. I would highlight for you that almost entirely the restitution is dedicated to making those individuals whole. And I think that's a really important point to note, that this money is dedicated to individuals who've been deprived of their security deposits, like Tatiana, if they were working with Four Star, or individuals who paid fees that they shouldn't have paid because they didn't actually cause the damage. They had a spot on their wall, and they paid to have the whole wall repainted, the ceiling repainted, the other wall repainted, because that makes the property look better for the next tenants, but it shouldn't be done on the back of the tenants who are moving out. So this $1 million is going to be put to good and appropriate use. The Attorney General's office is to be applauded for leading this effort, but also want to highlight again that security deposit protection statute that passed in 2022 gave the state a lot more power to balance out the dynamic, the imbalance between tenants and landlords throughout the state of Colorado, and that's why we're here today. That's why we partnered with the Attorney General's office in bringing this action, not only under the Consumer Protection Act, but also under the security deposit protection statute that the AG has authority over. So there are a lot of different things that came together to make this the first of its kind settlement in the state of Colorado.
Let me add one more on that, which is in 2019, the legislature changed our Colorado Consumer Protection Act and made two changes that helped us get this settlement today. First, it's not only intentional wrongdoing, but it's also reckless wrongdoing that is a basis for liability under our Colorado Consumer Protection Act. That was important because in this case, we could say to the company, you may not have intended to do this, but you set up systems that created a substantial risk that this would happen, and you basically looked the other way while this happened. The second point is there's civil penalties under the Colorado Consumer Protection Act. So even though the problem DA already noted is one they could have sought to take advantage of litigation, we had a club, which are these civil penalties, which I think helped bring them to the table as well. Yes?
In this case, was rekeying a pervasive issue that you came across? Because I noticed that Four Star now can't retain money from security deposit, including for rekeying. It also can only charge for rekeying if leases opt for Four Star rekey law. So I just thought that making those specificities was really interesting. Can you tell us more about that?
Let me start, and Dave already can elaborate. Four Star made a switch from the conventional keys to electronic keys, but their rekeying fee collection didn't miss a beat, even though the underlying cost of changing the code was negligible. That misled consumers, that took advantage of consumers, that ends because of this consent decree.
I think the Attorney General captured it very well. So the rekeying fee is one example that you'll see in the consent judgment and the complaint that was a focus of the investigation here, that tenants were charged a rekeying fee when they were moving out, even if they returned the keys to Four Star without any requirement or request from the future tenant, the next tenant, that the locks be changed out. So they were changing the locks, requiring new keys on every tenant that was moving out, and those fees remain the same, even after on some of the properties they went to an electronic key system, which, as the Attorney General indicated, is a snap of the finger process as opposed to having a locksmith come in and change out the entire lock on the door and new keys and so on. So those fees remain the same, and that's one example of what was going on here that was brought to our attention that the Attorney General's office and the District Attorney's office recognized to be an unfair and unjust fee upon tenants.
We have two final questions. Let's give them both, and then we'll call it a day. Yes, sir, and we'll give Tatiana the last one.
I was curious how the closure of the car center has affected operations with the Attorney General's office, including cases like this. Also, I saw there was a trial last week where attorneys from your office weren't able to access their exhibits. How are you dealing with this practically? What have been the practical effects? Where are your attorneys working?
We learned an important skill during the pandemic, which is that we can, when necessary, work remotely. That is what we are using, in addition to the collaboration and support from partners helping us access space as we need it. This is a challenge for our office. This is a test for our office. I will say our team members, closing this matter, the trial I mentioned last week, and so much more, are working effectively under these adverse conditions. This is not anything we remotely could have expected, but we're adapting to it remarkably well. Final question for Tatiana.
Is this four-star ruling only involve their apartments? It looks like they have single-family homes too, so I'm wondering, how that works.
Everything that Four Star operates is subject to this consent decree, insofar as anyone was a tenant of a single-family unit as opposed to an apartment. They're also covered in this action. I want to thank you all for joining us. We'll turn it back over to the aforementioned Lawrence Pacheco.